My pleasure. So the DABUS cases are very interesting ones. Essentially, it's Steve Thaler has created this complex neural network where there's these tiny little networks that get connected together, and he's going to go into this in a lot more detail. And each one of the networks is trained within some topic area, so to speak. And so then when they're connected, kind of through this controlled chaos, and then they form something like an idea. And then there are some filters there so that you can see the model itself can predict which ones of these, I think he calls them sentiments, are new and of interest, right? Kind of in the market. So he has created the model, but he doesn't create what problems it's supposed to solve or what types of solutions, right? It kind of figures that out on its own via these filters. And through this, there were two inventions that came out. One was having to do with food containers, and they were, the machine, the algorithm identified a way to have kind of flexible walls in the food container with a fractal profile. And the advantage of this is that when you stack them up, and then they don't stick together. And then the other invention was a warning light that flashes according to this kind of controlled chaos type of pattern. And this is supposed to attract people's attention more than just normal warning lights do now when they maybe flash at a constant frequency. So those were the two inventions. And then he worked with multiple lawyers, but led by Dr. Ryan Abbott is the kind of lead litigator that he's working with. And he filed patent applications around the whole world, and like I think almost every jurisdiction, if not every jurisdiction. And he listed as the inventor only the algorithm, so he calls it DABUS. And he's listed as the applicant, right? So he would own the patent, but he's not the inventor of the patent. So like I said, they were filed everywhere, and I guess I'll just keep going until I'm cut off in terms of what the status of that is. So I believe Europe was the first to take a stance and said, you can't do this. You need to identify a human inventor. Our law requires it. And the UK made a similar decision. These are being appealed, and I know that the DABUS team has already talked to some judges in the UK, and the UK has some interesting, they had some interesting ideas that might comply with their law, right? They said essentially if you would have filled out the forms differently, and then we might have allowed this, but you didn't. And specifically they said you could have listed yourself as, talking to Dr. Thaler, you could have listed yourself as a deemed inventor, kind of standing in for DABUS, but you didn't do it that way. And so you didn't comply with our formality requirements. So that we have UK and Europe said you can't do this. US said the same thing. Very recently in the US, a district court agreed with the patent office and said this is a requirement. It's already being appealed to the federal circuit. Now, meanwhile, South Africa, which is a registration system, thought this was completely fine. And so not only did they say you complied with our formality requirements, but because they're a registration system and they don't have substantive examination, there's an issued patent now in South Africa. Australia said you can't do this. The patent office said it didn't comply with the formality requirements, but then the DABUS team won in court. And that's being appealed as well. So as of right now, Australia says it's fine not to list a human inventor. It's fine to list an AI inventor. And then if this holding is upheld, and then this application in Australia will start its substantive examination. So that's the status right now of all the cases. And like I said, there are patent applications filed in many more jurisdictions where the DABUS team just has not yet received a yes or no in terms of whether it's allowed to only list an AI inventor.
Thank you very much, Kate, for the introduction. Now, I hope you are ready for your presentation. For the audience, I have also good news about Ben. He called me back on his cell phone, and he will be joining us, just after the Thaler team is done. So everything is fine. We just reverse our presentations. So Kate and Steve Thaler will go are going first already, and we are very happy to do so. So, Kate, in what form do you want to download something? Present PowerPoint or something like that?
Yeah,
So
so I'll do a screen share.
okay, screen share is open, and let's go with your main talk. And thanks for the little introduction.
Oh, absolutely. Okay. So you see my screen?
Not yet. Yes, we do now.
Wonderful. Okay, so I'm going to be talking about the potential impacts of this case. We're going to hear more about the technology from Steve when he can join. But for me, I'm going to say, what would this mean? What's the potential consequence of these different decisions that we've already kind of touched upon? And just to make sure we're all on the same page about patents generally, here are the general requirements that I'd say the vast majority of jurisdictions have. Like I said, not South Africa. South Africa is a registration. You just file it and it's a patent until somebody challenges it. But for most jurisdictions, the requirements are your invention has to be novel. So nobody could have described this before, presented this before, published this before. It needs to be non-obvious. So it can't just be taking one piece of technology and tweaking it in a very obvious way. There needs to be sufficient disclosure, meaning that because your claims can kind of evolve throughout the examination process, it needs to be shown from your original disclosure that your claims were supported, like that you actually knew the invention that you're trying to capture later, that you had a handle on that, and that the disclosure was sufficiently detailed to enable somebody of skill in the art to make and use it. So that because the quid pro quo, one of the quid pro quos provided by the patent system is to let people use your invention after your exclusivity is over. So it needs to let them do that. Another requirement is eligibility, which means it's just the type of thing that patent systems say can be patented. So for example, you can't patent an abstract idea or a pure business method or a product of nature in the US. And then you can patent things that are tied to technology. And then the final requirement is just to comply with formalities. And that's where the Davis cases really come in, right? So you need to complete the forms well. And now one of the issue here in front of us is, do you need a human inventor? And can you have an AI inventor? So we already talked about this, right? This is what Davis stands for. These were the patent filings that were filed. Here's where they were filed and who's made decisions about them so far. Now let's talk a little bit about what are some of the arguments on different sides. So an argument for saying that it is okay either to list an AI inventor or to not require a human inventor is that this might, the Davis teams has said, this will encourage the development of inventive machines and innovations, and then also to use them, right? So it will encourage companies to develop AI and to use AI. And it will also reduce the chances that an entity will claim undue human credit. Because if I, as a company, have a major innovation and I'm looking at the requirements and saying, well, I can't patent it unless I give credit to some human, even if it's not the human's invention, that creates an awkward situation where I'm kind of motivated to give some human that credit just so that we can try to protect our amazing product. Additional considerations are that allowing a non-human to be an inventor and not requiring human inventorship may improve consistency across different types of IP. So for example, in copyright, you don't need to list all of your authors. So if I, as a corporation, am saying this is my copyright, I've paid for it and I want the rights to it, then I, as the corporation, get that copyright. I don't need to spell out every one of my employees who is working on it. And it can also promote a quid pro quo disclosure instead of trade secret. In an earlier slide, I talked about how one of the requirements for patenting is sufficient disclosure, and you need to tell people how to do it and how to use it. And this not only will allow them to make and use the invention after your period of exclusivity, but they can even build on it in the meantime, where they can improve it. If you patented a base model, they can patent a more sophisticated or variation on that model. Otherwise, if we say you can't get a patent if there's no human inventor, and then if I'm convinced that that's the situation, I might just try as hard as I can to keep things in a black box and not let anybody understand how my technique is working. The possible alternatives to the current human inventorship requirement, well, that at least exists right now in the US and a few other jurisdictions, is to say it's fine to list an AI inventor, right? And this is what the DAPIS team is doing. You might not require listing of inventors at all. And I understand that this is what the situation is in Israel. And we just talked about how this is similar to what the situation is for copyright. And then the final possibility is to change what it means to be an inventor. And we already kind of touched on this with the judge from the UK about how he talked about the possibility of listing a human, but listing a human as a deemed inventor and not one that necessarily came up with the idea. Now, we've talked about some of the pros and cons of some of these. A few additional considerations are listed here. So one, for listing an AI inventor, it might be difficult to define an AI inventor, right? Code is pretty dynamic. There's different people are changing the code all the time based on new objectives and bugs that are found, et cetera. And then also AI code is changing itself as it's learning on new data, as long as that learning is permitted. So if you have a complicated code that might actually be doing multiple things, if it's changing in time, how are you going to differentiate one versus another? What does it mean to kind of name an AI inventor? Considerations for not requiring the listing of inventors is that you might reduce transaction costs during patent prosecution, because in the US, there are a lot of forms to fill out, and it can be a pain to get these forms filled out if the inventors are gone or if there's arguments about who contributed what. I think the situation is even more complicated in Germany, where there's a system where it's felt that the inventors get like a credit for a patent. There's a separate agreement that has to happen so that they get some sort of financial benefit for the patent. And then for not listing the inventors, another consideration is it can be harder to verify a chain of title. So if a company is coming after you and saying, I have a patent and you're infringing it, one of the things that is commonly done is to verify that the company actually owns the patent. And usually you start at the inventors and say, like, who did they assign their rights to? And then make sure that there's a continuous chain up until the current owner. That'll be harder if we don't know the starting point. I'm going to take a few slides to talk about terminology clarifications. One is to differentiate the topic we're talking about here from AI and patents. So a lot of organizations, a lot of entities talk about AI and patents. The Patent Office, the US Patent Office, the World Patent Office, many conferences, many different patent associated or patent associations talk about AI and patents. This is an umbrella term that includes many different things. So the first subcategory of that is new inventions that involve AI. So for example, if I came up with a new kind of neural network, right? Or another example is if I have a new use of AI. So suppose that there was an existing neural network that was really good at detecting people in images, and this was being used for a security type of purpose. And I'm like, well, now I want to take that and bring it over to automated driving and use it for a different purpose. And then a third example is a new use of an AI result. Okay, so I flipped my examples here. So the new use of AI result is pretty much what I said. The result's the same, here's the person, but you're using it a little bit differently. And the new use of the AI is kind of shoving AI into a different kind of workflow. All right, so that's category one, and category two is what we're talking about, where the technology, what's being patented, doesn't have AI, right? In all these other situations, there's something that's involving AI relating to the claims. In the second category, we don't really care about what the claims say. It could be about AI, or it doesn't need to be. But over here, the important part is that it was discovered fully or in part by AI, by an AI algorithm. So maybe a human was involved in part, or maybe a human wasn't involved at all. Another terminology clarification is the difference between inventors and owners. So inventors are the entities, typically people who came up with, who conceived of the invention. The owners are the entity that control, that file the patent application, that control how the patent's being prosecuted, that control the claim language, and control whether or not the patent's going to be asserted, licensed, etc. In the US, if there's no assignee, and then the owner is the inventor, right? Everything, and we talked about that with the chain of title. Everything starts with the inventor, and then it goes to an assignee. And that might be automatic if in their employment agreement, they have an obligation to assign, and then that kind of happens whether they like it, wanted to or not, but that's still part of the chain. If there is an assignee, and then the owner is the assignee, right? So the assignee is the entity that's controlling the patent prosecution and the patent assertion. For this,
Yes, there is a little moment. Let me welcome Steve Thaler to the room. Kate, you will be kind enough to continue your presentation. I just wanted to mention to everybody, Steve is here and he takes over after this. Okay, thank you very much, Kate.
Wonderful. So this is what's called a declaration, and it's generally required in the US. So an inventor has to sign a form that looks like this. This is the most common version of the form that's used. And you can see this highlighted text at the bottom where the inventor has to acknowledge that if they're lying, if they didn't really invent this, and then they might go to prison for 5 years and they might have a big fine, which I think is up to $200,000. So there is a potential big consequence about lying about being an inventor if you're not. As far as I know, there have not been any enforcements of this highlighted phrase, but nonetheless, it has to be something that an inventor is comfortable declaring. All right, another important terminology clarification is the difference between artificial narrow intelligence and artificial general intelligence. Artificial narrow intelligence is focused on a specific task. So if I'm trying to use a computer vision type of approach to detect, to predict whether a mole in a given image is cancerous or not, right? Or if I'm trying to teach a computer how to play the game of chess, or how to play the game of Go, or how to translate text from one language to another. All of these are narrow tasks. And it's supposed to, artificial narrow intelligence is supposed to implement a limited part of our mind, right? We're sitting down doing one thing. Now, contrast that to artificial general intelligence, where it's not focused on narrow tasks, but it's supposed to mimic the human mind generally. Most computer scientists, as far as I'm aware, seem to think that artificial general intelligence has high ties to what's called transfer learning. So if I as a human learn something in one context, and then I have a pretty strong capability of applying that into another context. You know, if I'm learn how to ride a bike as a kid, I might use that experience to help me drive a car, to learn how to drive a car later. If I learn how to be a good student and a good employee, I might use that to figure out how to do a decent job of hiring other people, right? To use that experience in a new context. One other clarification about artificial narrow and artificial general intelligence is some of the smarter people who I've talked to about this don't like this distinction. They think it's more of a spectrum. So, you know, artificial narrow is on one end, artificial general intelligence is on the other end, and it's not a black and white distinction. It's more of, you know, how sophisticated is your algorithm? So you can keep that in mind. When we're talking about, let's say, machine inventions through the course of this conversation, I would suggest that we think about a situation where the AI algorithm is not trained to solve a particular problem or to generate a particular type of solution. So it's not this kind of narrow AI as I described it. And the AI algorithm is designed to filter outputs so that it can find an output that's interesting, that, you know, is of potential interest, and maybe that it's new and has some significance. Is this artificial general intelligence? Well, maybe. I think if you have artificial general intelligence, it would probably have these characteristics. But I don't know that because you have these characteristics, you're going to say that this is an artificial general intelligence algorithm. I'd be curious to hear other people's opinions of this. But right, so now, if we think about what we're doing with the patent system, here's kind of some of the quid pro quo. So generally, the patent owners have a lot of benefits if they have a patent, right? They could say, I'm going to protect my market. I developed this technology, and I don't want anybody copying me. And in addition, if I've gotten many patents in this area, right, in this general field, and then I might build a moat, kind of a market dominion, where I'm like, don't even try to come in here, because I have so much protection that it's just not going to be worth your time to innovate in this area. It can give negotiation bargaining power, right? So if somebody comes after me and says, I'm going to sue you, if they're in the field, I'm going to say, well, watch out, because I have patents myself. So maybe we should negotiate instead. It can add value to your company from an investment standpoint, right? If investors see that you have a lot of patents, it's a good sign. And for a potential acquisition. Now, from society's standpoint, in terms of what are the benefits over here, well, by having a patent system, and then we're telling people that it's worth their time and their money to invest in discoveries, to invest in research, and to invest in marketing, right? So we're saying you have this protection, so go ahead and spend the time and the effort it takes to get this all the way to the market, because somebody won't just come in and copy you. And then finally, it promotes disclosing details about the invention, so that somebody can build upon my invention during my patent term or after, and so that once my patent is expired, or if I don't end up getting the patent, that somebody else can use that information. And these are, I would say, in line with here in the US, our constitutional basis for the patent system, where it's saying that the purpose of the patent system, I mean, not explicitly, but essentially what it's saying is the purpose of the patent system is to promote the progress of science and useful arts. And so we're telling these inventors, here are all of the advantages you can have by patenting, so go ahead and spend time trying to find these innovations and to promote progress. Now, if we step back and say, does IP protection remain justifiable if a machine conceives of the invention, right? So when we had these benefits from patent owners, benefits from society, do we have the same kind of quid pro quo if we have an AI algorithm that's inventing instead of a human? Well, from the patent owners, now remember, this isn't inventors, from the patent owner's perspective, the benefits stay the same. And now, what about society? The difference here is you're not going to be motivating an individual. You're not going to be motivating an human inventor to spend time developing technology or developing a particular invention or marketing that invention. Now, meanwhile, you will be promoting using and developing AI, right? Because this is how you're going to get those inventions. So this is a good thing that you'd be able to use. And in either case, you still have the benefit of promoting disclosure. So once an invention is developed, whether by or is identified, whether by a human or a machine, if you want the patent, you'd still need to disclose it. So there's still a quid pro quo that's slightly different than if we have a human inventor. And if we think about the potential justifications for identifying inventors, like why do we do this? Some countries don't, right? We've talked about the fact that Israel we don't identify authors and copyright. So what are some of the reasons why some jurisdictions require this? Well, a big one is that you're motivating the individual to invent. And patents are prestigious, and it's something that's nice on your resume, right? So it's a motivation there. It also informs society of your contribution, so that if somebody says, I want to have more inventions in this space, or I want to have a consultant in this space, and then I'll know which person to go to try to help me with that. There's a fairness argument, and it adds clarity to the chain of title, which we've talked about before. So it gives you that starting point to make sure that that whole chain is connected, and that the current alleged owner actually owns the patent. Now, if we're talking about not a human inventor, but a machine inventor, most of these justifications still apply, except for the top one. It's not going to be motivating an individual to invent. Again, it might be motivating an individual to develop AI or use AI, but not to invent. All right, so different kinds of potential inventorship requirements. Right now, I think the prominent inventorship requirement is that you need to have a human inventor, right? That's what Europe and the UK and the US have said. Another option is to permit listing an AI inventor, which is what the DABIS team is proposing. And this is what right now South Africa and Australia have said is fine. One possible drawback is, we've already talked about this. I think we've talked about this whole list, but I just wanted, I guess, to refresh your memory, right? So human inventorship, list AI, don't require listing of inventor, and change what it means to be an inventor. And in view of those four possibilities, I wanted to consider some hypotheticals. And in order to do that, we need to think about different roles. So in a first role, there's a coder, and this would be the person who coded the AI algorithm, right? So this is like Dr. Thaler. In a second role, there's a data contributor. And so this is an entity that said, you can use my data to train your AI algorithm, right? You might have one data contributor, you might have multiple data contributors. And the third role, the AI user. So this is the entity who's taking that trained AI algorithm and using it. And then, okay, there's the inventive AI output, right? And so they can see this, and maybe the AI algorithm itself was the one that said, this is interesting. And then the user's just sitting there saying, well, this is patentable because, or potentially patentable because the algorithm said so, or maybe it's a little more sophisticated. Let's consider a circumstance where the AI algorithm generates a result and detects that it's being an invention, right? And that none of the coder, data contributor, or AI solved the invention or had any involvement. They're involved in making or using the AI or training the AI, but they didn't contribute to the conception of this invention. And now we can think about, I told you the three roles, but I didn't specify whether or not there's overlap in the entities. So one situation is all three of these entities are the same. The coder figured out what the training data was, and was the same one that was sitting there when the AI algorithm popped out as, generated its output that corresponded to the invention. In other situations, they're not the same. So maybe the coder and the data contributor are the same, but different from the AI user, or maybe the data contributor and the AI user are the same, but different than the coder, or maybe they're all three different entities. All right, so let's think about the first possible inventorship requirement, which is what the US and UK and Europe have said so far, which is you need a human. Well, this is a pretty easy case because I told you, in our hypotheticals, humans did not contribute to the conception, so you can't get a patent. Regardless of whether there's an overlap between these different roles, in any of these circumstances, you can't get a patent unprotected. Now, potential inventorship requirement number 2 is what DABIS has been arguing for, says we should allow listing an AI inventor. And so in this case, the patent would be permitted, so long as it complies with the other patentability requirements. But when we look down into the specific circumstances, it gets a little more complicated. So if all of the entities, if there's one entity that is the coder, data contributor, and AI user, that's pretty easy. That's who owns the invention, right? There's really no other entity that would. But if we consider that the coder and the data contributors are the same entity, right? So the same, let's say, company is providing the training data and had generated the AI code itself. But that's different from the AI user, right? It's different from the person that was sitting in front of their computer when the patentable or the invention was identified on the screen. So then, who gets to own the patent? I would speculate that it might be the coder or the data contributor, but that does bring up an interesting kind of philosophical question in terms of then what's to motivate the AI user to ever say here was the invention, right? To say I spotted it, I was using it and I spotted it. And then in the third possibility, when the data contributor and the AI user are the same entity, but different from the coder, now it's getting a little bit tricky, right? So if you say like, I'm in the first case, you kind of know who owned the AI, right? And then there's a license out to the AI user. So the coder and data contributor are the ones that develop the AI, and that's why I would say that they're the likely contributor. But here, if the data contributor and the coder are different entities, then they're each kind of to credit for what the AI became, right? Without the training data, the AI algorithm's useless. And without the code, the AI algorithm doesn't exist. So I don't know which one of these entities would be the original owners of the patent. And then if all three of the entities are different entities, it's very tricky. I mean, it mainly has the complications that we just talked about before, but we've just added an extra level of complexity. All right, now let's talk about the third potential inventorship requirement, where we say you don't even need to list inventors. In this case, then the patent's permitted, right? We don't need to have human inventorship, so we can have a patent. But then going to the question of who owns it, you know, again, if all the entities are the same, it's easy. If the coder and the data contributor are the same, this is kind of tricky. Like, who the AI user was the one that was sitting there when the result popped up. And if we haven't specified that we are allowing, you know, the owner, like the owner to kind of stand in for the AI, sorry, not the owner, but like the entities that created the AI. And then I'd say that there's an argument that the AI user is going to be the owner because they were the ones using it. They were, you know, it was kind of like a work for hire with this code, with this AI code. If the data contributors and the AI user are the same entity, but the coder is different, or in this last circumstance where everyone's different, again, my initial thought is that I think the AI user here might get to be the owner, right? So this is a potentially different outcome than what we were talking about before. And then finally, in the fourth requirement, where we can list an inventor as a deemed inventor, right? So the human is the deemed inventor. And then we have to decide essentially who would that be? Who gets to be the deemed inventor? Again, the first situation is very easy. When we have a different parties involved, I think they're all tricky here. I don't know who would be able to claim that. I mean, does it matter who kind of built the AI, was the genesis of the AI, in which case the coder and the data contributor should be the deemed inventor, or does it matter who was sitting there actually filing the patent application, right? Who saw the result? And I don't know the answer to that. So I hope that these examples have provided like some sense that I think things can get very complicated here. And that it's worth the time to not just say, you know, should we allow patents for where there's no human inventor or where an AI algorithm was an inventor, but to really think about what design of the patent system we would want in these kind of circumstances, right? So I agree, like I appreciate that the first question is, should these be allowed? But very quickly, and one of the important considerations for how we're going to approach the situation is in the details. I think it would be wise to think about the purpose of the patent systems, like what actual motivation do we want to provide, and then think about these different types of ideas. Because given the high degree of collaboration that now exists, you know, around the world in pretty sophisticated markets, I think it's quite likely that we will see many of these circumstances that we reviewed in the hypotheticals.
Thank you very much, Kate. I don't think we want to have discussion now before Steve is talking, but I have one question of clarification. Whom did you want to be beneficiary of that patent? You know, who would benefit from the actual, you know, financial or other, you know, benefits? Would that be Thaler? Would that be Dabus? What would it mean for Dabus to benefit from it? if so. I just didn't see, I'm sure it would have been someplace in the legal papers, but I wasn't sure I've had it in your presentation.
I think in terms of what is being proposed by the DABIS team, once again, this goes to the clarification between inventors and owners. So the benefit, the financial benefit always goes to the owners, with the exception of Germany. And that's because of kind of this chain between the inventors and the owners. So in the case of DABIS, and then the financial benefit would be to Dr. Thaler.
Thank you very much. So now this is a good introduction for Dr. Thaler. Steve, would you be ready to take over? Hello, Dr. Thaler. Can you hear me? Well,
please switch on your microphone.
Steve, is your microphone up? Very good. It looks like Steve is up. Please talk to us on the mic.
And now I'm unmuted. Can you hear me?
Now you are muted.
Yes.
And we can hear you.
Good.
Please-
Okay, that's a good
Please
start.
with this. Kate gave us a very good start, but I'm sure you follow as the inventor. Thank you very much. Please tell us more. We have like 30 minutes for this session remaining under the circumstances. Sorry for the slight change of plans, but we are happy for Kate and Steve to be, joining us a little bit ahead of the schedule. Thank you very much, guys. So, Steve.
Well, I appreciated what I heard from Dr. Gaudry. Hope I can do as well. You can see the slide, right?
Yes, we can.
Okay. I'm very grateful for this opportunity to talk about DABIS, largely because I figure heavily in the press. There's a lot of reporting on the legal issue, but not very much reporting on the technical and scientific side of this artificial intelligence. And just to let you know that DABIS is a real thing, here you see one rendition of the paradigm in hardware. So it is a combination of hardware and software. But my frustration is this, typically when I read about this technology in the press, it's misinterpreted. And this is probably one chance to actually clarify what's going on within the system.
Exactly right, Steve. Let's go ahead to the system because we are all dying to learn more.
But the problem is that, excuse me, 1 second. The problem is that usually I am blamed for not building a sentient AI, one that has subjective feelings. And that is not the case. Essentially, it is a sentient being, as I'm about to argue, and that qualifies it as an inventor and probably closer to human than most would expect. So to make sure we're all on the same wavelength, let's go for a definition of sentience. And I had to go to Merriam-Webster for this. Definition of the noun sentience. Number one is a circular definition as far as I'm concerned. But number two, I think hits the mark. Sentience is a feeling or sensation as distinguished from a perception or thought. And by perception, we're building an AI that models the brain looking out at the environment through its sensory channels and making sense of the world. And then alternately, it's having reorganization, recombination of old perceptions into new ideas, or coming to conclusions about that interpreted reality. But the feeling or sensation has an entirely internal or endogenous origin, and it's something not easily described and probably akin to issues such as qualia or subjective feelings. And I got a kick out of the example used on the Merriam-Webster page In essence, people are assigning human-like sentience to today's AI, despite the undeniable and inarguable fact that no such AI exists as yet. And that's from Lance Elliott in Forbes. And I note that Forbes has not come back to me to get my opinion about that statement. But nevertheless, this is the definition of sentience I'm going to go with. Probably back in 1975, I started thinking about artificial neural networks and their emulation of neurobiology. And I was aware of two kinds of molecular signaling in the brain. The first was synaptic, in which certain neurons directed their signaling molecules, their neurotransmitters, toward other neurons. But that's only about half of what's going on within the brain, because there's also volume transmission. There are colonies of neurons that specialize in infiltrating the entire cortex with these neurotransmitters that are randomly diffusing through the synaptic clefts. And that is a source of noise or perturbation, as I will refer to it later on and throughout this talk. And that plays an important role in invention and discovery, and probably cognition, consciousness, and sentience in general. So with that in mind, probably in the early 90s, I began experimenting with taking artificial neural networks and injecting these perturbations and various concentrations into them with their inputs pinned, so that there was essentially no input from the environment. Everything coming off the net was the result of this internal noise. So what I discovered, this is a rather general plot that pertains to any neural network, biological, inorganic, and I keep getting a doorbell. Is that a comment, question?
Is saying that two people are coming, and actually the person who just came is Ben Gertzel. So welcome, Ben, and we listen to your cognitive architecture description with Steve.
But in this plot, what I'm doing is taking a neural network whose inputs are pinned. It's not sensitive to the external environment. And I'm steadily ramping up the concentration of perturbations or these the simulated neurotransmitters, and keeping track of the rate at which patterns, in other words, notions, are being evolved by the system. So as you'd guess, with the inputs blocked and only internal perturbation available, when there is no perturbation, of course, there's no turnover from the net. No ideas are coming off the net. But then as we begin to gradually increase the concentration of these neurotransmitters, these perturbations, we reach a peak. We start off with very sporadic kinds of output, what I call low fractal dimension. And then steadily we see an increase in rate. It's rather linear at this point. And I guess this corresponds to waking up, having no coffee, being rather groggy, but then suddenly you become awake and thoughts tend to come rapidly and linearly, probably a regime of lucidity. But this is a phase transition boundary, because slightly above that point in synaptic perturbation, the network begins to degrade its memories, simply because the perturbations are interfering with internal pattern completion, and hence the reconstruction of memory. So what you get are one-offs, maybe two-offs from what the network has already learned. In other words, potential ideas. And the closer you are to this peak, the more plausible are these notions coming off the net. And of course, what happens at this point, the pattern generation increases, but they're nonsensical as we get into what I call the W regime. And then finally, as we add even more of these perturbations, the network freezes, because all these neurons are pinned in a given state. So there is no turnover. So I call that the deer in the headlights regime, pure traumatized halting of all cognition. But it's important to realize that this regime that I call V, near this peak, is where new potential ideas are being born. Below that, basically memories are being generated. Out here, you see nonsense and basically fragmentary ideas that are reforming. This V regime inspired the architecture on the right, which I patented back in 1994, basically a generator critic architecture, in which I'm taking one network absorbing a conceptual space in terms of different training exemplars and introducing those critical levels of perturbation. And what it does is starts generating new potential ideas. We add a critic or a discriminator to take a look at those and to anthropomorphize if it gets frustrated by not seeing a solution to a problem. It can basically ramp up the perturbation to make those ideas being generated more twisted. In other words, wild guesses at solutions and so forth. But then when the critic or discriminator sees a promising idea, what it can do is lower the injected noise. And mind you, all these networks are constantly training. With less noise, the idea is able to be absorbed through learning into the imagination engine, as I call it. And then later on, this becomes an accumulation. It stores an accumulation of ideas, the more salient ones, and it can be interrogated now as a content addressable memory. This is pretty important, and it's you have to realize that there are different rhythms associated with these different regimes. Out here, of course, near this peak, we're representative of lucidity. The network is outputting ideas in a fairly linear fashion, but then as we begin to descend down this slope, they tend to be more sporadic. You might call it sputtering going on, because you really can't predict the turnover, when the next idea is coming off the net. And that's important for an important affordance for looking for ideas in these systems. So it's the tidal variation back and forth across this boundary. We basically form fragmentary ideas out here in the W regime, fall back into V when we're generating reasonable ideas. And then out here in the U regime, the network is essentially reactivating those learned ideas through mild forms of noise. So the problem with that whole architecture that Davis addresses is that if we get more ambitious and we try and create 100 billion neuron generators, we run into problems. These are typically auto-associative nets, for those familiar with the terminology. And it's easy to freeze in memories, relatively easy. But the problem is typically these critics or discriminators have to be heteroassociative. And what we're having to do essentially is create as many inputs as there are outputs in the generator. So if you've got 100 billion outputs from this network, you basically square that number to arrive at the number of weights involved. So 100 billion squared, probably trillions of connection weights would be involved also in that discriminator. And that's prohibitive, because as we up the number of connection weights, we also up the number of required training exemplars and training time. It's just totally impractical. And I know Paul Werbos on several occasions in his talks brings up this issue of how does Cortex generate ideas, and what part of the brain essentially is evaluating those ideas. Well, thalamus is only a few 100,000 neurons, in particular the thalamic reticular nucleus, and it has to keep track of what 100 billion neurons are doing up here in cortex within the brain. So there had to be a way of condensing the representation of those patterns being generated in cortex.
Steve, this is very important. Let us give ourselves more time for this. I think by now you've created the interest in doubles. because you presented your old cognitive architecture. And I think our presentation of your work will be continued. And because we have more time than Ben Goertzel, but I think let us interject Ben Goertzel now for less than 60 minutes, and then we come back to Dabus and the conversation about it for the rest of the session. Would that be acceptable to you? Because this is the only way not to have Ben say nothing for us, whereas he is not guilty of not being here earlier on because he was, there was a snafu in information. So could we have the second part of your presentation, which I believe is exactly to present us Dabus, which we are actually very, very interested because this is hard to get information in about 60 minutes, a little bit less. Would that be acceptable to you?
I'm along for the ride. Okay, as you may recall from the previous slides, I was making the point that we can build these generative systems bigger and bigger. The problem is that the generative part gets too big, and the critical part of it, the critics, the discriminators, have to get bigger and more comprehensive. And the problem with that is, of course, there are too many training exemplars required, too much training time. It just becomes utterly impractical. So we need some way of condensing information in a generator system so that critics and discriminators can evaluate them. And the answer, I claim, comes from Donald Hebb and his Hebbian theory that basically neurons that fire together wire together. So if we're looking at a traditional neural network, even deep learning, neuron A is sensitive to some subfeature of the environment. It fires, and if neuron B is sensitive to another subfeature of the environment, it fires, and as a result, it tends to connect the two neurons together via very simple learning rules. Now, I've extended that to what I call modified Hebbian theory, in which we have whole neural networks that are binding together. And the way this works, for those of you familiar with autoencoders, essentially they can basically take a pattern, and if there's a memory of that pattern stored in the net or a near hit to that pattern, it reconstructs at the other end. So the difference between the input and output pattern tends towards zero. When that happens, I call that resonance. In other words, this network is familiar with some pattern from the environment. Likewise, there can be another network. It can be an autoencoder, an associative memory, and it resonates. So when the two neural networks resonate, they're familiar with their respective pieces of the environment. They wire themselves together. So this is a whole conceptual space, not just one memory wiring itself together with another conceptual space. So here's Davis. Davis begins as a swarm, often a vast swarm of these autoencoders or associative memories. And the environment is constantly feeding it patterns, and all of these networks are constantly training. But the thing is, when the environment presents pattern A to this array of neural networks, one of them responds. Of course, the pattern is being applied in parallel to all of these networks at the same time. So A responds, the A conceptual space. Likewise, if B is applied to the array, then the B net resonates. But then if A and B both co-resonate in response to A and B being presented simultaneously, they wire themselves together. So essentially, this could be the wheel conceptual space, B could be the axle conceptual space, and we see or hear about a wheel axle combination, and it wires itself together. And the way we store those bonding strengths is through another big associative memory that notes the linkage between A and B and stores that. and making that a stable memory that can be later activated with mild forms of noise. So what happens, it's beyond the scope of this talk. I do have a paper along these lines, but what happens over time through successive rounds of generative learning in which different topologies form, different chains of neural networks, we can essentially correct, mentor, and then finally let the system go with noise, and it starts to generate its own ideas without any kind of feedback from a human being. So what happens is concepts form, not just A and B, but A, B, C, D, E, and also through watching the environment or a mentor, the consequences of those ideas are learned. So this may be A, B, C, D, E concepts joining together into a complex concept, but now you have consequence chains that are developing as a response. And if they do incorporate a network containing very critical, maybe existential information, then the whole network is reinforced. And that happens via what I call a foveator. It's watching the environment. It can shift an attention window around looking for the so-called hot buttons. And once it does that, it can neuromodulate. It can inject more or less of the simulated neurotransmitters or perturbations. So with everything constantly learning, if you reduce the noise, then you tend to allow these blocks, these different conceptual spaces to combine. And of course, all the time, there are latent or subliminal ideas that are forming that really haven't contacted with a hot button. In a way, it's like the game, the carnival game of High Striker, where you hit the pallet and launch the object toward the bell to ring it. Well, when these consequence chains contact the impactful memories, then the whole thing's reinforced because it's being watched by the foveator. And of course, if you have multiple hot buttons being incorporated into these vast topological chains, you can increase the neuromodulation even more, dropping maybe the background noise so that now the whole chain is reinforced. And note that functional definitions are forming, because here's the base concept in blue, and then it transitions to green. That's the consequence. Well, this is the complex thing that does such and such. Maybe H, I, J, K are going to happen. And of course, that's wired up to the object, bound, and can reappear again due to noise. And you have the original impactful affect being incorporated. So things appear along with their own definitions. Plus, there's intuition. We know that, first of all, something impactful is about to happen. We are, again, secreting the equivalent of neurotransmitters, but that's an intuition. Well, something good or bad is about to happen. And by golly, this foveator can track the trail that this chain is defining and actually understand what's going on. So we can look retrospectively through the chain back in time. Bridging logic happens if this is a wheel and an axle. The bridging logic basically is, well, an axle penetrating into the center of a wheel. So it qualifies what's there. And of course, if you want to tailor the memory to fit within the entire chain, noise can be utilized until you have a fit. It's like having a jigsaw puzzle. When a piece doesn't quite fit, well, you bite off a piece of it and it basically comes into the chain and fits as a whole. But the point is, just like in the creativity machine, concepts and their consequences ripen after multiple swings in neuromodulation, up and down. So you get complete ideas forming not after just one cycle, but probably after many cycles. So here is Davis schematic. the system in a nutshell, we have one or more chaining models in which these ideas and their consequences are forming up. There's usually a novelty filter, which has the ability to emphasize the new or the novel chains that are forming up, the new ideas. And then you've got the filtered chaining model, which of course is now incorporating one of these hot button modules. And classification is very simple. Basically, it's a foveator looking at and saying, aha, we've enlisted a hot button, reinforce, so the noise can be injected. It can either emulate things like cortical adrenaline injection. And the high end, you also get a traumatic kind of learning because, again, all the networks are pinned. There's no turnover. So it's a very quiescent environment in which these modules can link together. It can also do things like inject in a titrating kind of scheme, excitatory versus inhibitory perturbations, so that you might have high adrenaline levels or noradrenaline levels, and you inject the equivalent of serotonin and neutralize it. So now we're allowing all these blocks to glom together into these complex ideas. And note, all the time there is a large associative memory, I call a master associative memory, that's watching all the chains, storing memories of them, especially the more significant, the more frequent of them. And in the end, it actually helps to dictate chain completion. You add noise and you have a partial idea, but the chain completion takes over and completes. You also might have noticed that in that initial slide, we had a camera watching multiple chaining models at the same time. And the big advantage I found, rather than resorting to supercomputing techniques like InfiniBand and remote direct memory access, essentially optically combining. And when you do that, use that analog technique, you're able to miniaturize all these models, but because it's a sparse representation, you tend to preserve the shapes, the topologies, and so forth that can be interpreted by the novelty filter at all the other processing stages downstream. So it does greatly assist in the condensing of information, probably that question that Paul Werbos is constantly asking about how to get a small neural network to evaluate the ideas of a very large neural network. So what we see happening essentially is the same kind of swings we saw before, only instead of patterns, there are chains being evolved. And the chain evolution rate keeps changing too, just like with the patterns. And what we see essentially is an evolution. We inject noise into the chaining model and you start seeing ideas, whole or fragmentary. And then if a hot button is detected, then the noise is reduced, allowing the whole system to settle back into the quiescent regime U, where mild noise can then reawaken or reactivate those chains or ideas. So the tidal variation is very important to this process. And the selective ripening that takes place as a result, extremely important to the process. So my point is that the whole of cognition can be emulated with these systems, and they are indeed extensible. They're autopoietic. They're also transcendent. All we need to do is start adding more and more of these associative memories. And essentially we can create more and more information as a result. But perception results from the environment supplying different input patterns. The chains form in response to model that environment. And of course, there's always a little bit of noise involved, the perturbation, because that way the system can come up with alternative interpretations of what it's directly observing. And of course, that noise is regulated by the foveators. Thought takes place as we inject a little bit more of these neurotransmitters or perturbations. And now we start seeing the growth, almost like plant life growing to generate more and more consequences, as well as more and more ideas. But the feeling is largely associated with that pattern of the rhythm with which these ideas are forming. So when they are highly chaotic, it's more like a frenzy. That certainly has an internal genesis, and that is interpreted by the neural networks within DABUS. Of course, then when things get calmed down and these perturbations are removed, then these feelings, basically, these ideas bubble to the surface. But the point here is that the triggering of a frantic or tranquil chain turnover is associated with different states. Certainly a feeling. I feel frenzied, I feel relaxed, and so forth. And those are very hard to describe kinds of phenomena. So in a nutshell, here's what's happening. First, I've straightened out a chain as an example. We have multiple memories combining into a compound concept. And of course, they contact with warm buttons, with hot buttons, and so forth. But the foveator is looking at that and saying, aha, I see a hot button, and releasing different levels of these perturbations and or simulated neurotransmitters. But the volume transmitters, as those disturbances, essentially induce frenzied or a tranquil state, as well as somatic effects. And certainly if you were secreting cortical adrenaline or even adrenaline, there are other effects such as sweating, vasodilation, heartbeat, and so forth. And that has a feedback effect too, because the brain is observing all of the somatic effects. So again, these are feelings that have no explanation within the external world. They are arising internally, and they have no neat explanation for what's going on. So when those disturbances are launched, we have in DABUS an artificial feeling of impending penalty or reward. And the important thing to note is that when you secrete these perturbations, these networks begin to pulsate, to sputter, if you will, in very uneven and sporadic kinds of rhythms. And it's that sporadic rhythm which is picked up by the novelty filters, the anomaly detectors, and so forth. So the foveator is able to track through these chains, having an intuition that something significant is about to happen, but now it can examine all of the elements of these chains until it gets to the hot button. So it's like ants following a scent trail back toward the big issue at hand. So in neurobiology, Darwin creates the hot buttons. The hot buttons take the form of those parts of brain that show up upon delivery. Things like the Mora response, essentially the fear of falling, basically the infant throwing his arms out to stop a fall, heat, cold, hunger, and thirst. And my claim is that these chains basically extend to these fundamental, these primitive kinds of concerns. You may not know that offhand, but if you examine the chains internally, you find them headed towards these primitive responses. In artificial intelligence, Darwin has created the humans, who in turn create the hot buttons. And the hot buttons don't have to do with autopoiesis or self-preservation. They can simply be, well, I have to get this particular task done. So the hot buttons are now characteristic of the task at hand. So note, most of all, that this is conception. What in legal circles is being debated, are these systems actually just doing a parametric optimization? What the narrow AI is doing nowadays, and what I did probably 30 years ago. They are combining conceptual spaces into ideas. So one prime example I use is the toothbrush. Way back in the 90s, I invented a novel toothbrush for a big company using creativity machines. But that was basically the juggling of design parameters until a critic said, aha, that will achieve the objective. The real invention of the toothbrush, though, was done centuries ago by the Chinese, who decided to take a bamboo stick hog's whiskers into it to create a tool for dental hygiene. That was the conception. After that, it was basically material substitutions and fine tuning of the parameters. And I would say that Davos is conceiving, and it's doing that sentiently because it's having an emotional response, an effective response to what it is conceiving. So, anyone still there?
Thank you very much. We have 29 persons in the room. Kate, I understand, had to go to her other obligations. So now is the time probably for a few questions or comments. David, Kelley, you are an official commentator. Would you like to comment on this? Are you even in the room? No? I'm another official commentator. I am not going to be reading my short presentation because we don't have the time, and also because Kate is not in the room and with Steve we talk a lot. So I would be really open to other people, posing fast questions, and because the session is, getting long since it started a bit late. Any questions from those who didn't have the opportunity to talk about that? If not, oh yeah, thank you very much, Steve. I think this was a very important content for thing. Davos is a really novel cognitive architecture. I understand it combines Steve's first, cognitive architecture where there was this critic, but now there is so much stuff built upon this critic that we already encounter topics like free will of the AI. I think that in terms of application, a big topic is whether if the AI is the discoverer, then, and it in principle cannot benefit from the discovery, then is there a practical need for doing, actually assigning it to the AI instead of a person? I think there's a due diligence, if AI is really doing the discovery as an engineer would, that would make sense. I think the one issue that I thought Kate would mention, and I don't know that she did, were details of the judgment by the Supreme Court judge of Australia, Justice Beach, which were very subtle and exactly distinguished the discoverer from a human being who might profit from that. So that's worth reading. It's easy to find on the internet. And that would be my comment questions. Steve, do you want to address any of this? Are you there?
Who, me, Steve?
Yeah, Steve.
What are we addressing? The legal issues?
My question in general, what is the biggest difference between Davos and your first cognitive architecture, because it is visible but could have, escaped some people? And what is the main non-legal, like philosophical issue in allowing patents? For me, this is social issue. What it means for a patent holder, for a non-human to be patent holder, other than something kind of abstract. Is there a practical sense in it? Okay.
Well, I mean, the most notable difference from the prior technology, the generator critic architectures, is that the critics are looking at activation patterns, on-off patterns of neurons. And that's no longer the case. Essentially, we're looking at chains of neural networks, complex topologies that are setting, that are forming. So rather than be looking microscopically at a generator, it's looking mesoscopically at it. It's looking at these chains that are forming. And I'm sure that the endoreticular formation of thalamus is not looking at every activation of a neuron in cortex. It's looking at these topologies that are forming. So that's a big paradigm shift in neural networks and artificial intelligence. So in my opinion, it goes far beyond the deep learning and all of the other generative stuff out there, which quite frankly is a rehash of what I did 30 years ago. Sorry to create any kind of waves, but that is the case. Again, my frustration is that everyone keeps thinking about the legal aspect and saying, well, AI has progressed to the point where we can see them generating new ideas, new patents, and so forth. And my claim is, no, it's not going to be any AI. It's going to be the DABUS architecture that creates the non-trivial, the broad kinds of things. But this is extensible. Something people are talking about theoretically, it's already been done, but that's a recurrent theme. I talk and I'm ignored.
So for me, this is really big what you said at the last moment, that this is this topological view on, evaluating those patterns instead of, node by node. This is big. So without further ado, Marcin, who comes with the last question or comment.
I just wanted to ask if you think that the same will apply. We were talking here about, in the context of some kind of privilege given to the system inventing something. But what about responsibility? Is it do you think it will equally well apply to the question about responsibility of this system? Not in the case of invention, but in the case of some kind of action.
I'm not quite understanding the question.
Yeah, because we were talking here mainly in the sense if artificial system can be awarded some kind of privilege of being owner of the patent. Now, with this comes question, what about if we consider not invention, but some action of artificial system about responsibility, moral or legal responsibility of artificial system?
Well, the way I see cognition is basically pattern recognition and pattern generation. So I would say the invention is in the category of pattern generation. But then again, you think about cognition in general. If I take a step, or if I decide what I'm going to say next, a lot of things that are considered trivial in every day, those are minor acts of invention. So, look on the internet. I've already worked with the military and robotics and so forth, generating novel strategies and tactics on the battlefield. The old technology was put to use there. It's also being an application of DABUS to essentially generate very complex kinds of reactions. And they talk. I mean, you may not have the Hollywood level kinds of audio coming off of them, but they generate the equivalent of pigeon language. Basically bad English, but one can infer it, especially if one interacts with the system. So it's simply a matter of some rather common kinds of AI techniques to make the pigeon language, or pigeon English in this case, look more sophisticated. So the pattern recognition is taking place on unprecedented scales, what we'd call perception, and the inventive stuff that can encompass everything, from inventing a light bulb or a new kind of star drive for space vehicles. it's all related to pattern generation, the more mundane kinds of patterns. So again, Davis is doing that, but now it's doing it on unprecedented scales. And it's driven by sentience, it's driven by subjective feelings, largely guided by the secretion of these perturbations that are equivalent to reward and penalty neurotransmitters. So I would say, go ahead.
Yes. I say, so this means that we can consider some kind of moral responsibility the same way. Yeah, that if the system is acting in some way which is harmful, then in this case we can consider moral responsibility of the system.
Right. I mean, yeah, these systems will probably be responsible for their actions, which is another aspect of the legal debate. You know, if they commit a crime, they can be held responsible. They're culpable.
What would that mean in practical terms, though? Are you going to jail the system? I mean, what this is kind of new field, really, new waters.
Well, you can correct the system. It's exactly analogous to raising a child. You know, you can either teach it ethics and values, or you can just let it go. I mean, if you're a scientist wanting to see the way things go naturally, yeah, as long as you can pull the plug at any time. Otherwise, it's going to be the same as raising a child, correcting, you know, trying to impress one's morality on the system. But you know, the fascinating part of this is that I
lost your voice.
We are unable to hear you. I think his system must have frozen because he is not moving. Okay.
Okay, so.
All right, Steve, are you here? Okay. I think this is one way to finish this conversation, really. Thank you, everybody. I think there was a lot of connection between patternist philosophy by Goerzel and patternist application. Remember, Goerzel of major applications by Steve. And thank you very much for patience with many infelicities today, but I think we had something really valuable here. Thank you.